name is Najma binti Jari, matric holder of A18 A1144. So in this case, Telkozat had requested Fasola, which is famous figure in the country, to be a spokesperson to their company in the next 2 years, which Fasola also agreed with this. But suddenly there is a trade war happen between the US and China. Things get worse when PM Malaysia also follow the ban and terminate the Huawei transaction into Malaysia. So the issue here is, does the endorsement contract between Telkozat and Fasola being affected by the Chinese policy of government as defined under Section 57, subsection 2 of Contract Act 1950. It is held that both parties cannot claim the compensation. First, because the contract decided to be frustration and discharged even though there are no breach or nor default by both parties. Second, during the performance, there is a trade war happen and put Fasola contract with Telkozat to the point it cannot be performed. Third, Huawei and Telkozat are related because Telkozat has been used a device technology by Huawei. So when Huawei being banned by Malaysia, automatically the device's technology transaction end, and indirectly the contract with Fasola also end forthwith. Pursuant to the Section 57 subsection 2, both are not entitled to claim compensation because the contract become frustrated because of the unknown matter that happened.
Assalamualaikum, my name is Nur Salihah binti Mataha, matric number A18A0483. Today I want to present about the law. The question that arose in the case of Telkozat and Fasola, which is, does the endorsement contract of Fasola being affected by the change of government policy as defined under Section 57 subsection 2 Contract Act 1915. It is proven that Telkozat signed a confirmation contract with a well-known national figure named Fasola, where according to Telkozat, Fasola will be the company's spokesperson for the next 3 years, which is between 2019 to December 2021. The consideration of an agreement is impossible of performance when lost or destroyed something that was the basis of the contract. Secondly is the absence of the event on which the contract is. Thirdly is government intervention involving the basis of contract, failure to obtain a license, and occurrence of natural disaster. In relation to the issue, the contract decided to be frustrated and terminated even if there was no breach from either party. In fact, the frustration that occurred with the Telkozat and Fasola when this unexpected thing happened, which was a trade war. 57 subsection 2 Contract Act 1915 prescribed 5 circumstances where adjustment of object cannot perform, but in this case, which are A, B, and C. For A, lost or destroyed something that was the basis of the contract. In this case, the basis of the contract is a technology from Huawei to Telkozat. However, when Huawei transaction is deactive and cause the Telkozat to be unable to do anything. And for B is the absence of the event on which the contract is based. Telkozat and Fasola, there was an event that was not expected by both parties. For the C is government intervention involving the basis of contract. The contract unenforceable where the decision of the Malaysia Prime Minister stopped Huawei transaction into Malaysia.
My name is Nazaka binti Muhammad. Matric number is A18A0488. For the cases, in Malaysia, there are examples where a contract is considered frustrated under Section 57 Class 2. The first case is Pacific Forest Industry Sdn Bhd and another, and Liwenchi and another, should not be considered difficult to do if one cannot settle his debt. If it is possible or illegal to perform, the person who is supposed to perform part of his contract will demand an enhance. So this case shows that the legal commitment of the parties cannot be delayed simply because the task become heavier due to the change of circumstance. Second case, Guan Aimo, Sdn Bhd and another, and Selangor Properties. This case is really opened by the operator for having frustrated the contract. It is reasonable to conclude that the second aspect of dissatisfaction is satisfactory, such as the fact that no party is responsible for the MCO. The court must be convinced, especially in a mortgage arrangement, that the party concerned is facing financial difficulties that make it difficult to pay rent, and that there is no way to change the party circumstance. Third case is Yu Ho and others, and Limat Maju Development Sdn Bhd and another appear. The deal is deemed frustrated under Section 57 due to the outbreak of Japanese encephalitis. In 20 March 1999, the state government declared the state of Negeri Sembilan as a JE infected area. banning the keeping and sale of pig in the affected areas. The tapping arrangement and provision of services made between the two parties were invalid on the ground of contractual frustration due to the JE outbreak, according to the High Court. The last cases is Lee Yan Hon and Rose Sediam Berhad and Metro Cham Sediam Berhad. An illustration of a constitutional clause merely exemplifies a concept, and it cannot be exhaustive as hypothesis. The declaration of law in an as illustration cannot be construed as establishing fundamental law, and it does not obligate the court to give the provision a meaning that is inconsistent with its words. Thank you.
For the application, in Telco-Z v Fasola case, there are a few elements that apply, such as offer. As we know, in every contract there must be an offer or proposal required for the formation of an agreement. In Section 2A of the Contract Acta 1950, the definition states that an offer is a statement of willingness to another party to do or refrain from doing something, with the aim of obtaining that party concerned to do something or refraining from doing something. In this case, Telco-Z has made an offer to a well-known figure, namely Fasola, to sign a contract with the company. The contract signed between Telco-Z and Fasola states that Fasola will have to be a company spokesperson in the next 3 years, from January 2019 to December 2021. Next, acceptance. A contract is deemed to come into force when acceptance occurs. A contract will exist when both parties have reached an agreement and the law recognizes the right and responsibility arising from the agreement. Based on this case, Fasola has accepted the offer and agreed to sign a contract with the company that she is entitled to be company spokesperson in the next 3 years from January 2019 to December 2021.
Hi, Assalamualaikum. My name is Ros Anita binti Azali. My metric number is A180803. Okay, today I'm going to continue from the previous presenter, the intention to create legal action. Okay, the parties concerned must have intent or demand to have an intention to enter into a legal relationship. There are two determinants of the type of intent by the courts, namely socially and agreements. Okay, domestic social agreements are assumed to have no intention of establish a legal relationship. For example, Telco-Z. While this type of business is assumed to exist with the intent to establish a legal relationship. For example, Fasola. Both of these presumptions are allowed by the court to be challenged by any party to contract by bringing sufficient evidence or proof. Okay, next, the considerations. The last element found in the case of Telco-Z versus Fasola is the considerations. These considerations occur after the offers and acceptation, where its contract is only valid if there is a consideration or something contracted. In other words, the execute of the contracts must contain a reply. The word considerations is defined in Section 2 of the Act, which state that when at the request of the promise or other person has made or refrains from making it, an act or prohibitions or promise is called in return for the promise. Okay, the Section 26 of the Contract Act 1950 also provides that as a general rule, an unconscionable agreement is invalid. Consideration is something that is the material of a contract, that is something that is exchange or contributions in a contract. In this case, between Telco-Z and Fasola, the consideration that is the material of their contract, in that Fasola has to carry out these duties at the company's spokesperson within the given period, while Telco-Z pay according to the duties performed by Fasola. Okay, thank you.
So, in conclusion, for the issue, does the endorsement contract between Fasola and Telco-Z being affected or not? The answer is yes. The endorsement contract affected by the change of government policy. The contract between both parties automatically end because the unforeseen event that happened, which is a trade war. This thing causes both parties unable to do anything when it happens.